Calificas para ser legal. ¿Quieres saber? Solo llama al abogado Andrés Mejer.
Good morning. My name is Andrés Mejer. I'm an immigration attorney. I'm the author of Do You Qualify for U.S. Legal Status? Welcome to the English version of our radio show. I'm in the car here. Right behind me is Mount Laurel. That's a New Jersey field office. I just came out with a client, and I'm waiting to go back again with another client. Today I want to talk to you about what can happen if you lie to your attorney. I want to give you two specific examples of real cases that happened just last week. Now, the circumstances are real, but the names are not. So, first case is George. His criminal record affected him. We'll talk about what do I mean by that. And the second is Maria, who lied to immigration officer about her entries into the U.S. and what that means. So thank you for listening in here in the first part of our radio show, Para Ser Legal, which is not in its usual time because unfortunately I did have to go with a client to immigration. The USCIS field office is right behind me. Not that you can really see, it's just a brick wall. But here's two scenarios that happened just last week. The first, George. Now, George, and that's not his real name, has been in removal proceedings since 2011. He had two prior immigration attorneys before coming to us. He came to us only about 3 weeks ago. The first thing that we do with every new client or every potential client is we evaluate his or her options. So one, does he qualify for some form of relief? Number two, does he have something in his background, an arrest, a conviction that could disqualify him? And third, we create a plan. So George said he was never arrested other than by ICE, that he had no criminal record, and we determined together that asylum was his best option, and we put a plan in place to be able to have a petition filed with the judge at the date of his court appearance, which is 3 weeks away. So we made a follow-up appointment for him to bring in. We gave him a list of documents to come in with all his documents, fill out our questionnaire so that we can prepare the petition. At the appointment, he didn't show up. We called back. What happened? Hey, he said, something came up. We rescheduled it. We informed him, listen, you don't have a lot of time. You can't just bring this to us the day before and expect us to be ready. Second appointment, he also doesn't show up. Then he doesn't take our phone calls. The day before court, he stops in the office at 5:48 just as some of my team members were leaving. Obviously, no petition, nothing could be prepared from 6 o'clock at night to 9 a.m. the next morning. It needed to be filed with Texas, and we needed to get a receipt, and none of that could happen the day or a couple hours before the appearance. So at the court appearance, we went. The judge was unhappy with him is an understatement. The judge almost gave him an order of removal on that day because it was a very old case, and he was told the last time, do not come back without a petition. We asked the judge to give us more time. The judge gave him a trial date and gave us time before then to prepare the petitions and prepare for trial. Now, after that court hearing, we went with another client, and George was leaving. Well, ICE grabbed George and detained him. And somebody was kind enough to let us know. We went and we talked to ICE. Said, what are you doing? He's represented by counsel. You can't just take him. What? They did, but they allowed us to. We insisted that we meet him. And in going and talking to George, we finally got the full story. He told us he was, despite what he promised that he had never been arrested, he was already convicted of 2 DUIs. Now that was 2011, 2012. That was not the end. That was not the. If it was just that, it would be okay because he was previously released. But he had 2 pending DUIs that he failed to appear in 2015. That means he had 2 active orders for his arrest. He walked into a building where ICE has their offices, their law enforcement. They looked him up. They found he had an order of arrest. They arrested him. That never happened to me before. in immigration court. I mean, he was already processed. He's already in removal proceedings. What worse can happen? But here he had an order. He had 2 orders of arrest for criminal charges, nothing to do with immigration. Now, had he told us in advance, maybe there's something we could have done. Certainly not the day before. But if he told us 3 weeks before, we could have communicated with those courts. We could have found out what the bail amount was. We could have processed the bail, so he would not have had an active warrant for his arrest. Now, he would still have to confront and defend those 2 DUIs. And in prior shows, we've talked about what are the common defense strategies for DUIs. But we didn't have that opportunity because he didn't confide to us and he didn't tell us. And it was preventable, it was avoidable, but I understand why he didn't go to court. If he was convicted of either of those DUIs, he's facing minimum 6 months in jail. Mandatory, no discretion. Conviction means 6 months in jail for each case. But unfortunately, not confronting your problems does not make them go away. Lying to your attorney does not make them go away. It's unfortunate that he had to learn that the hard way. So anybody who's watching this, please, if you had any interaction with immigration or law enforcement, for whatever reason, let your attorney know. It can affect your case. Particularly if you have an order of arrest. Look, if you fail to appear, even if it's a traffic ticket, you're driving without a license, you go in, you plead guilty, they give you a $500 fine, you make the first payment, you take a payment plan, you don't make the rest payments, they don't go away. The judge gives you a bench warrant, and next time they pull you over, even for a small infraction, you're arrested, you go to jail, and then ICE can pick you up. Don't let that happen to you. Find an attorney, get some help, get some advice, make sure that you don't have an order of arrest. Very important. 100% preventable what happened to George had he worked with his attorneys or even his prior attorneys, because we since reached out to them and he said, look, he would appear, he would make a payment plan, he wouldn't pay, he wouldn't show up, and we only heard from him a couple days before court. It's the same thing that happened to us. So unfortunately, George did not take responsibility for his scenario, but I hope anybody listening to this learns from that and reaches out to me, to another immigration attorney, to a criminal defense attorney. We can help you. If not, somebody else can help you. The important thing is you find out your options. If you have any questions, you can give us a call at 888-888-0307, or you can find us on Facebook or on the web at Andrés Mejer Law. So that was the first scenario. George, he forgot to disclose, he failed to tell us that he had orders of arrest. Not a good option. Now this happened just last week. Now let's talk about Maria. This is the second scenario. So for those who are just tuning in, the subject of today is why lying to your immigration attorney is not a good idea. We're talking about 2 case studies that happened just last week. That had the client been honest with us, we could have done things differently. So George had an order of arrest, had 2. Those were not defended, those were not addressed. So when he went to ICE, he got detained. Now we're going to talk about Maria. Again, Maria's not her real name. The facts are real, but her name is not, to protect her privacy. Maria has 3 United States children. 3 United States citizen children. They were all born here. One of them is over 18 and is in the military. The oldest is 22, and she could file for her mother. Now, but here's the thing. In order for mom to get her green card, in order for mom to get a green card based on her daughter's applying for her, she needs legal entry into the United States. In prior episodes of this program, we've talked about what are the requirements for a family-based petition. And there are basically 2, sometimes 3. In Maria's situation, there's just 2. 1, you have to document the relationship, that her son really is her son, that her daughter really is her daughter. So, we typically always know who mom is. Birth certificate always has mom's name. Birth certificate does not always have dad's name. Now, if there's any doubt, if there's any ambiguity, there's always a DNA test, there's photos, there's a variety of ways to prove that the relationship is legitimate. But that's step one. Step two is the change of status. Now, change of status, that's where Maria would go from undocumented or illegal or a student visa or a tourist visa or an H-1B, whatever kind of visa she has, to a lawful permanent resident. And that can happen either in the U.S. or outside the U.S. If it's outside of the U.S., well, once she leaves, she needs a waiver because she's already been in the U.S. more than 1 year without permission. And because of that, when she leaves, she's inadmissible for 10 years unless she applies and receives a waiver. But she doesn't qualify for a waiver because she needs to show parents or spouse that are U.S. citizen a green card in order to apply for a waiver. She doesn't have that. She has children who are U.S. citizens. So her only option would be change of status, meaning inside. How does that happen? So to change your status inside the U.S., Maria needs forgive me, I'm trying to play with the camera while I'm talking to you. So Maria needs an immediate relative, which her daughter is. Her daughter's 22 and a U.S. citizen, and she needs legal entry into the U.S. Now, Maria told us she entered in 1986 and without permission, meaning illegally. So she does not have legal entry. That's where parole in place comes in. That's where her son, who's a Marine, can make a difference. Parole in place was created in 2013 under the Obama administration. The idea is that U.S. citizens or green card holders, people who are serving their country and have undocumented immediate relatives like parents, should not have to worry that the parents or their relatives are going to be deported while their life is at risk, while they're serving their country. So they created parole in place. Parole in place essentially gives somebody legal entry into the U.S., hugely important, work authorization, and protection from deportation. So that's what we did for Maria. We asked Maria when she entered the United States. She said 1986. We proved that her son was in the military. We proved that it is her son. We proved that Maria was a good moral person that deserved discretion and consideration, and it was approved. So that approval is an admission into the U.S. It's a legal fiction, but because the statute says you must have been inspected, admitted, or paroled. Well, parole in place is a function of parole. So Maria was paroled into the United States. With that, she had legal entry. With that, her daughter, who was 22, could file for her adjustment of status for her to get a green card to the U.S. Her son, who was a Marine, could not file for his mother because he was under 21 years old. But his older sister was over 21 and a U.S. citizen. She could. So that's what we did. So sister applied for mom, and in October we had an interview. The interview went very well. Officer said she was going to recommend approval for a green card, but she just was waiting on the results of the background search. Perfect. Client said there was no negative hits. She only had one arrest, and that arrest was in the 90s, and it was dismissed. So months go by, no decision. We send emails, we send letters, we ask the officer what's going on. Last week we got called in back for another interview. Before we went in, I asked the client, I said, listen, it is very rare that we have a second interview. Every single time there's a second interview, there's some kind of problem that immigration is looking at. Is there anything you didn't tell me? Is there an arrest? Is there multiple entries? Is there any fraud? Is there anything you didn't tell me? And Maria said, no, there's nothing. So I'm scratching my head wondering, I don't know what we're doing here for a second interview. But we went. And I asked the officer before we started, I said, officer, last time you said you were inclined to approve. What happened? She said, I just have some questions about her entries. So I asked the officer, what do you mean? She answered that already. So I immediately knew that there was a problem. Turned out the problem was much more significant than I thought. So Maria Maria's problem was she entered the U.S. more than once. Problem was she lied about it and she got caught. In her petition, she said she only entered in 1986. In the first interview, she said she only entered in 1986. At this second interview last week, she said she started saying the same thing, and the officer asked her, "When was your last entry to the U.S.?" She said November 86. And the officer asked, "Did you ever leave?" She said no. Officer asked her again, "Are you sure?" "Yeah, I'm sure. I only entered once." Officer asked a third time, "Are you really, really sure?" And Maria said again, "Yes, I only entered once and I never left." So the officer turns the monitor around and says, "Is this you?" And Maria looks at it and says, "I don't think so." First she says no. Then she said, "Are you sure? Because this came up when we ran your fingerprints." Then she said, "Oh yeah, that is me. You want to tell me what happened?" So then here's what happened. Maria left the U.S. in 2000 with her children because her father was deathly ill and ultimately passed away. So she went back to help him in his final days, said goodbye, and then came into the U.S. Now, her kids are U.S. citizens, so they entered without a problem. But Maria did have a problem. She was caught at the border on July 14th of 2000, and she was returned to Mexico. Why is that a problem? Well, first of all, she lied to an officer. But outside of that, why is that a problem? The law changed in 1997 so that if you come into the U.S. either before 97 or after 97, and you either overstay or turn illegally. Give you my family's example. We came in 1981. We came in as tourists, we entered legally, but we overstayed our visas. The moment we overstayed, we accrued what's called unlawful presence, time in the United States without permission. Anybody who's an adult, meaning over 18, and after 1997 is in the U.S. for more than 1 year without permission, meaning more than 365 days, and leaves, cannot come into the United States without applying and receiving a waiver. And here there was proof that she left the U.S. after 97, in 2000 by her testimony, tried to come back in and was not allowed. So in 2000 she did enter the U.S., probably the very next day is what she said, but she accrued unlawful presence and she did not file and receive a waiver. She's subject to what's called the permanent bar. That means she must now stay outside of the U.S. for 10 years. And there is no waiver for that. None whatsoever. So, had we known that this has happened, we never would have filed for adjustment of status. Just, we know she's inadmissible, and that's the problem. Too often, my clients, and not just, the immigrants in general, believe if they don't tell their attorney something, it's like it didn't happen. At the end of the day, immigration has your whole world when they fingerprint you. I only have access to you. I only know what you share with me. If you're not honest with me, I can't guide you and I can't help you. So the officer wanted a sworn statement. And this was a 2-hour-long interview. At the end of it, she gave a conclusion and said, "Ma'am, you are inadmissible into the United States because of the multiple entries. You are subject to the permanent bar, and there is no waiver for this. Number 2, you lied to me. You gave me you made a material misrepresentation. At the first interview, the petition you signed was incorrect. At the interview, I asked you, you lied. Today, when I asked you, you lied again. And it was only when I showed you that I knew you had previously entered that you admitted it. Because you lied to immigration officer, you made a material misrepresentation, you're also inadmissible to the U.S. Now, I instructed Maria not to sign that document because there was nothing there that was going to help her. I also had her and her daughter withdraw her green card petition. Why did I do that? Because if I didn't, it would have been denied, and she would have been referred to ICE custody. She would have been placed in removal proceedings. I didn't want that to happen. Now, that may still happen. We are in the climate that we're in. I withdrew the application and I took her out of the building as quickly as possible to avoid any interaction with ICE. Had I not been there, she would have signed the document, she would have gotten denied that day, and she would have been turned over to ICE, and ICE would have processed her. That's what would have happened if I had not been there. Not because I'm the greatest attorney on earth, not because of that, but because I knew what was happening, and I was able to guide her and say, do not sign something that's not in your best interest. She had nothing to gain by signing that document. The officer already could prove that she lied. The officer already could prove that she had multiple entries. She gained nothing by signing it and only did her harm. So we left. Now we're going to try to reapply for the parole in place. Her employment authorization had lapsed because of her parole, because we got her employment authorization under her green card petition. We are now going to request under the parole, but now the case is a whole lot harder. I don't know if they're going to grant it because there's proof in the file that she lied to an officer. So, incredibly important to be honest with your attorney. Here we just talked about two examples of things that in one case could have gone horribly wrong, in another case it did go wrong by not being honest with your attorney. My name is Andrés Mejer. I'm happy to answer any of your questions either now or in the future. Feel free to give us a call at 888-888-0307. If you want a copy of our book, Do You Qualify for U.S. Legal Status? You can contact us on Facebook, on our web, or call the office, 888-888-0307. The book talks about the 9 principal paths to legal status. If you're in New Jersey, I'll send it to you free. If you're outside of New Jersey, I'll send you an electronic version. Thank you for listening. Until next week.
Calificas para ser legal, ¿quieres saber? Solo llama al abogado Andrés Mejer.